This episode was produced by Bach Pro Se. Run your own legal research at prose.trybach.com.
You know, usually when you travel to a foreign country, you actually have months to prepare. You download the language app, you figure out the exchange rate, maybe study a map of the city. You get your bearings before you ever step foot on the plane.
Right, yeah. You build a mental framework so you aren't just completely lost the second you arrive.
Exactly. But imagine just waking up one morning and boom, you are instantly airdropped into the middle of a foreign capital. You don't speak a single word of the language, the street signs look like hieroglyphics, and some stranger just walks up and hands you a ticking countdown clock.
Oh, man, yeah.
That intense, disorienting, not in your stomach panic, that is exactly what it feels like to open your front door and be handed a stack of legal papers by a process server.
It is the absolute definition of a shock to the system. I mean, in the blink of an eye, you are officially a pro se litigant, meaning a person representing themselves without a lawyer right in the middle of a family law case.
And if you find yourself in that exact situation, specifically dealing with a custody or timesharing petition in Broward County, Florida, well, consider us your translators today. We are pulling from this massive stack of localized sources for this deep dive.
Right, a lot of dense material.
Yeah, we've got the Florida family law rules, state statutes, local administrative orders from Broward County, and official clerk of courts data. We're using all of that to build you a practical survival guide and translate the legalese so you know exactly what to expect.
And, before we get into the weeds, we do have to lay down the ultimate ground rule for this conversation. We are mapping out the terrain for you, but this is not legal advice.
Right. Definitely not.
And we aren't taking sides. Whether you are the one who filed the paperwork or the one who just got served, we're just looking impartially at the rules of the road as they are literally written in these documents.
All right, so let's look at that ticking clock you just got handed. You're standing on your porch, holding a petition. Before you even think about the actual facts of your case, who gets the kids on holidays, who pays what, the very first thing you have to fight is the calendar itself.
And that calendar is incredibly unforgiving. The rules in Florida dictate that, generally speaking, you have exactly 20 days after being served with that initial paperwork to file a formal written response.
20 days. Wow. I mean, that feels incredibly fast when your entire life is being upended. Are we talking business days or calendar days here?
Calendar days.
Oh, wow.
Yeah. The exact mechanics of counting them, what happens if day 20 lands on a Sunday or a major court holiday, that's governed by specific civil procedure rules, so you really have to look at a calendar carefully. But that 20-day mark is your baseline. The day the process server physically hands you those papers, that is day 0.
Okay, so let's talk about human nature for a second here, because I think this is where so many people trip up. If someone hands you a massive legal document full of claims about you as a parent,
right,
and you completely disagree with them, your first instinct is just to react immediately.
Oh, absolutely.
You pick up the phone, you call your ex, you fire off a furious text message, or maybe you even, call the clerk's office to complain. If this is a tennis match and the petitioner just served the ball over the net, does yelling from the baseline count as hitting the ball back?
It absolutely does not, and that is a vital point to understand about how this legal system operates. Informal communication means 0 to the court.
0.
0. You could send 100 long emails to your ex explaining why they are wrong, but if you do not file a formal, legally recognized pleading with the clerk of courts, the judge literally doesn't see it. In the eyes of the court, you just stood on the tennis court with your racket down and watched the ball bounce past you.
Okay, so if I just let the ball bounce past me, what actually happens on day 21?
You forfeit the point. But it's actually worse than that. The referee essentially packs up the net and assumes the match is over.
Wait, really?
Yeah. In legal terms, the other side can ask the court to enter what is called a default against you.
A default? That sounds pretty ominous. I mean, if I default on a loan, they take my car. What are they taking here?
They are taking away your right to argue.
Oh.
Yeah. If a default is entered, it means the court can just proceed without you. The judge can issue a final judgment based entirely on what your ex asked for in their petition without you ever getting the opportunity to present your side of the story or, submit your own evidence or defend yourself.
Wow. So just by doing nothing or by sending an angry text instead of the right paperwork, the court just assumes you agree with everything they asked for?
Effectively, yes. Now, the law does provide a tiny bit of grace. You can actually file your answer at any point before the default is formally entered into the record by the clerk or the judge. So if it's day 22 and they haven't filed for default yet, you might still squeeze it in. but, I mean, you are playing with fire.
Let's say the absolute worst happens. I bury my head in the sand, day 25 rolls around, and a default is entered. Can I undo it? Like, whoops, my bad, I didn't understand the rules.
You can try, but I didn't understand the rules won't cut it. Courts do have the power to set aside a default, but it is a massive uphill battle. You have to file a really complex motion proving you had a legally valid excuse for missing the deadline.
Like a real emergency.
Right, something substantial, not just forgetfulness. And you also have to prove you actually have a valid defense to the original claims. The time and money you spend trying to undo a default is enormous. Avoiding it entirely is the single most important thing you can do.
So if I can't just send an email and I can't just call the judge, what does a formal legal response actually look like? Am I just, like, writing a letter on notebook paper?
No, it looks like very specific paperwork. The Florida Supreme Court actually has approved standardized forms for this exact situation. Depending on the case, there's a specific form just to answer the petition, basically going line by line, admitting or denying their claims. That's Form 12.983B.
Okay, 12.983B.
But if you want to make your own claims against them, say you want primary custody, there is a different form for an answer mixed with a counterpetition, Form 12.983C.
All right, so you find the right standardized form, you fill it out, you file it with the court, and you send a copy to the other side, all within 20 days. You've officially returned the serve. Now, I imagine the natural reaction here is to take a deep breath and think, great, I'll just wait for my court date to argue my case.
And that is the second biggest mistake people make, because once you are in this system, you are all in. The court isn't just going to take your word for anything. Which brings us to a massive, incredibly tedious hurdle, which is mandatory disclosure.
Mandatory disclosure, meaning I have to show my cards.
Exactly. The family law rules, specifically Rule 12.285, dictate that you cannot make financial claims or claims about how you can support a child without backing them up with hard, documented evidence. And you are on another ticking clock. You have to exchange this evidence with the other party within 45 days of being served.
Let me stop you right there and push back on this a bit, because I know exactly what you were thinking if you're listening to this. Family law cases, especially the ones we are talking about, they're usually about custody, right? Timesharing. Who gets the kids on Thanksgiving? If I think my ex is just using this lawsuit to go fishing for my new bank account balances, or they just want to know exactly what my salary is at my new job, isn't this a massive invasion of privacy?
It really feels like it.
Yeah, I mean, why do I have to hand over my pay stubs to an ex just to see my kids?
I completely understand why it feels that way. It feels incredibly invasive, especially when tensions are already sky high. But the court fundamentally cannot do its job without that information. A judge cannot fairly calculate state-mandated child support or assess how a time-sharing arrangement will financially impact the children's daily lives without a complete, mathematically accurate picture of both households.
So the court stance is essentially, your privacy takes a backseat to the math required to protect the kids.
Yes. The court has a duty to protect the best interests of the child, and that requires knowing exactly what resources are available. That is why it is called mandatory disclosure. It is completely non-negotiable.
Okay, so what exactly is the court forcing me to hand over within this 45-day window?
The centerpiece is the family law financial affidavit. This is a sworn, notarized document where you detail, practically every penny of your income, your daily living expenses, your assets, and your debts. And the state actually uses two different forms for this, depending on your income bracket.
Really? How does that break down?
There is a slightly shorter form, Form 12.902B, if your gross annual income is under $50,000, and a much more detailed, complex form, 12.902, if you make $50,000 or more.
And obviously, I can't just write down, I make 40 grand and call it a day, right? Yep. I have to prove it.
Right. You have to attach the receipts. You have to provide the past year's federal and state tax returns, recent pay stubs, bank statements, W-2s, all of it.
I remember looking at the sources for this, and it mentioned a 17-category list of documents. 17 categories.
It's a lot.
Imagine being a freelance worker or a small business owner trying to track all that down while dealing with a messy breakup.
It is a phenomenal amount of administrative work. That 17-category list is required if your case is moving toward a final permanent resolution. It includes things like gift tax returns, real estate deeds, retirement account statements, credit card statements. It is just exhaustive.
But the sources also mentioned a shorter list, right? Like a 4-category list.
Yeah. Yes, there is a distinction based on what stage you're at. If you are just having an initial temporary hearing, for example, maybe you need temporary child support, ordered immediately just to keep the lights on and the rent paid while the larger case drags on, the court won't make you produce all 17 categories for that quick hearing.
That's a relief.
Yeah, you only need to provide a shorter 4-category list of the most immediate financial documents, but eventually, for the final trial, you will need the full 17.
But what if I just refuse? Or, what if I just miss the 45-day deadline because I'm completely overwhelmed?
The consequences are severe. If you don't provide your mandatory disclosure, the judge can refuse to let you present any of your financial evidence at trial, or worse, they could dismiss your financial requests entirely. You are effectively tying your own hands behind your back.
Okay, let's step back and look at the whole battlefield here. You filed your formal response in 20 days. You spent weeks gathering tax returns and bank statements, and you've dumped this massive box of financial disclosure on your ex, and they've done the exact same to you. Now, both sides have dumped mountains of paperwork onto the clerk's desk. If left alone, you two would just drown in that paperwork for years. The court knows this, which is why they forced both of you into a room to organize the chaos. And that brings us to the case management conference.
Right, also known as the CMC. This is governed by Rule 12.210, and it's essentially a mandatory meeting with the judge to figure out exactly where the case stands.
So a CMC is basically like a project manager status meeting at work. You aren't actually finishing the project, or in this case, arguing the trial right then and there. You're just looking at a whiteboard, figuring out who is doing what, looking at what documents are still missing, and setting deadlines.
That's a really great way to look at it. It is primarily a status and scheduling meeting. The judge will look at discovery, what financial information still needs to be shared. They'll look at whether expert witnesses need to be appointed, or if a psychological home study is required for the kids.
And our sources get really specific here about how this plays out in Broward County, right?
They do. If your case is assigned to Division 40 in Broward County, they have very specific local administrative rules. Case management conferences in that division are generally held on Friday mornings, rapidly cycling through cases starting right at 8:15 a.m.
Friday morning at 8:15 a.m.
Yeah.
You definitely do not want to hit snooze on that. Do I actually have to take off work and go down to the courthouse?
The default expectation is absolutely that you appear in person. Now, Broward County does have a system for appearing remotely by phone, using a service called Court Call. But you cannot just dial in from your car on a whim because you didn't feel like driving.
Let me guess, there's a catch.
A strict one. The judge must give you advance permission to use the remote service, and, crucially, you must have completely finished filing all of your mandatory disclosure documents first. If you haven't handed over your financial affidavit and your tax returns, you do not get the privilege of calling in. You are showing up in person at 8:15 a.m.
Oh, man. The court is basically saying, do your homework if you want the perks. I love that. Now, earlier I called this a project manager meeting, but I feel like that might give someone a false sense of security. Like they might show up in sweatpants thinking it's just about picking dates on a calendar. Can the judge actually make real decisions at a CMC?
You hit the nail on the head. That is the big danger here. While it is an organizational meeting, the judge absolutely can make binding temporary decisions right then and there.
Really? Like what?
Well, if one party desperately needs temporary child support or a temporary timesharing schedule needs to be established because the parents are fighting every day at school pickup, the judge has the authority to order it on the spot at the CMC.
So you can't walk in unprepared.
Yeah.
You have to be ready to argue temporary stakes.
Exactly. And whatever the judge decides at that conference will be written into a formal order, and that written order controls your life and your case moving forward. It is a highly consequential Friday morning.
All right, so you survived the Friday morning CMC. The judge has looked at your file, they've looked at their completely packed docket for the year, and they realize they really do not want this case to go to a full-blown trial. Trials take days, they cost taxpayers money, and they clog up the system. So before you get your day in court, the system pulls out its favorite tool to force a compromise, which is mediation.
Yeah, and this is where we see a really fascinating intersection between what the state of Florida says and what Broward County actually does. Under state statute, specifically statute 61.183, the law says a judge may order mediation in cases involving custody or timesharing. It's permissive.
May, meaning it's optional.
Right. But when we look at the local administrative orders for Broward County, the county practically makes it mandatory. In Broward, a trial or final hearing date will simply not be set until the parties have attended mediation.
So the state says, sure, you can try mediation, but the county says, if you want a trial date from us, you are sitting down at the negotiation table first.
Exactly. They are aggressively pushing you to settle this yourselves before they let you take up precious trial time. And naturally, there are prerequisites before you can even schedule it. Before the judge will sign the order sending you to mediation, both parties must have their current financial affidavits on file.
Which goes right back to the mandatory disclosure.
Precisely. I mean, you cannot negotiate a fair settlement if you are in the dark about the financial facts. Once the affidavits are in and the order is signed, the clock starts again. Generally, mediation must be completed within 75 days of that first mediation conference being scheduled.
Okay, let's talk about what actually happens in that room. You show up for mediation. Who is running this? Is the judge sitting at the head of the table?
No, the judge is not involved at all. It is run by a neutral, state-certified mediator. Broward County actually has a subsidized program for this called the Court Mediation and Arbitration Program, or CMA, which parties can use.
So here is my big question. If this mediator is totally neutral and they are a judge, that means they have absolutely zero power to force either of you to agree to anything.
Right.
So what's the point? If two parents have been fiercely battling over custody, suing each other, forcing financial disclosures, aren't they just going to sit in a room, cross their arms, and glare at each other for 3 hours?
It's a great question, and it really gets to the psychology of the legal system. The mediator cannot force a ruling. They can't bang a gavel. But their superpower is reframing the conflict for both of you.
How do they do that?
Well, when you are in the thick of a family law dispute, you are entirely focused on winning your specific argument. A good mediator steps in and forces you to look at the massive looming risk of a trial. They remind you both that if you don't figure out a compromise today, you are going to hand over the power to make the most intimate decisions about your children's lives, like where they sleep, where they go for the holidays, to a complete stranger in a black robe who has only read a file about you.
Oh, wow. So it's an exercise in risk assessment. The mediator is basically saying, do you want to retain control over your own family, even if it means compromising, or do you want to roll the dice with a judge who might give you nothing?
That is exactly what it is. And the process itself is physically designed to help cool tempers. You don't actually have to just sit and glare at each other. The rules heavily utilize something called caucusing.
Caucusing, like in politics.
Similar concept, yeah. It means the mediator can actually separate you. You can go into one private room, your ex goes into another, and the mediator shuttles back and forth between you, carrying offers and counteroffers. It takes the immediate heat out of the room. You don't have to look at each other while you evaluate the offers.
That makes so much sense. Just having physical walls between you probably lowers the heart rate immensely. And if, through all that shuttle diplomacy, you actually manage to reach an agreement.
Then the mediator drafts it up in writing, both of you sign it, and it gets submitted to the judge. If the judge approves it, which they almost always do, it becomes a binding court order, and your case is essentially resolved. You never have to go to trial.
So let's summarize this intense journey we've just mapped out for you today. If you are served with a family law petition in Broward County, your very first job is to beat the 20-day clock and file a formal written response. No angry text messages, just approved court forms.
Right.
Then within 45 days, you have to completely open your financial life, providing cash returns and pay stubs, whether you want to or not. Next, you have to show up in person, likely on a Friday morning at 8:15 a.m., ready to project manage your case and handle temporary orders at a case management conference. And finally, before you ever get near a trial date, you have to sit down with a neutral mediator and negotiate in good faith to try and settle the whole thing yourselves.
It is an absolute gauntlet.
It really is. And we want to remind you that if you were doing this pro se in Broward County, you aren't totally alone in the wilderness. The Clerk of Courts runs a pro se self-help unit. You can find it at the main Central Courthouse complex. That's 201 SE 6th Street, room 02140 in Fort Lauderdale. They cannot give you legal advice, and they won't fill out the forms for you, but they can point you to the right paperwork and explain the basic procedures we've talked about today.
And, as we wrap up this mapping of the rules, I want to leave you with a thought that moves beyond just what these statutes require to what they actually do to human beings.
Okay, I'm listening.
We've spent this entire time talking about how strict and bureaucratic the system is. Counting exactly 20 days, filing the precise standardized form, providing a 17-category list of financial documents. But think about the reality of the people involved. Does forcing two people who are already going through an incredibly emotional, messy, and painful breakup to adhere to this cold, rigid legal structure actually teach them how to communicate better as co-parents in the future? Or does this entire bureaucratic gauntlet just add a thick layer of trauma to an already painful split?
Man, that is a really heavy question. Do these strict rules build a bridge for the future, or do they just build a higher wall between two parents? Brings us right back to where we started. You've been dropped into this foreign country, you're translating the street signs, you're watching the ticking clock, but at the end of the day, when the legal case is over, you still have to figure out how to live there. Thank you for joining us on this deep dive. We hope we've helped translate at least a few of those street signs for you today.